Welcome to the Oxford Undergraduate Law Podcast, where we discuss the law, its relationship with our society, and its implications on our lives. My name is Chum Siddiq, and I'm one of your podcast editors for this year. This series was made possible by the generous support of Crown Office Chambers, one of the leading London sets of chambers specialising in civil and commercial work. This episode is a particularly special one. In November, I was honoured to be joined by Professor Sheila Jasanoff. Professor Jasanoff is Fulbright Professor of Science and Technology Studies, STS for short, at the Harvard Kennedy School. She is a pioneer in her field, having authored more than 130 articles and chapters, and being author or editor of more than 15 books, with the most recent being The Ethics of Invention and Can Science Make Sense of Life? Her work explores the role of science and technology in the law, politics, and policy of modern democracies. She founded and directs the STS Program at Harvard, and prior to this, she was the founding chair of the STS department at Cornell. All of this led to her being the 2022 Holberg Prize holder for her prolific and pioneering efforts in the field. Now, why is this episode a particularly special one? Well, in November, the Oxford Law Faculty ran its Clarendon Law Lecture Series for this year. For those who may not know, each year the Oxford Law Faculty invites a distinguished guest speaker to deliver 3 lectures over the span of 3 days on their specialised area of law. Well, this year, our Clarendon Law lecturer was none other than Professor Jasanoff, delivering 3 lectures together entitled Science, Technology and the Constitution of Modernity. As part of a collaboration with the law faculty, I sat down with Professor Jasanoff on the morning of her second lecture to have a discussion both supplementing and extending beyond her 3 lectures. The first portion of our discussion elucidates the key conceptual ideas pertinent to STS thinking and its relation to law, and the latter portion questions the more specific positions Professor Jasanoff has voiced in her works with regards to intellectual property, especially in relation to the most recent legal developments, such as the environment, AI, and the concept of personhood. This episode is therefore complementary to the Clarendon Lecture Series, all publicly available on the Oxford Faculty of Law website and YouTube channel, and we therefore encourage our listeners to also look at these lectures. I truly hope you enjoyed this conversation as much as I did, and please note that as we are moving towards video podcasts, the video and audio quality will only improve in subsequent episodes. Thank you, Professor Jasanoff, for joining us today. For the benefit of our listeners, I guess the first foundational question would be to ask about your specialty in STS. You've mentioned in the past that you've had quite a broad range in coming to STS. You did a PhD in linguistics, and you were also in environmental law when you came across STS. So could you outline for the benefit of our listeners what STS is, and moreover, what in particular drew you to STS as a lawyer?
Thanks, first of all, let me thank you for welcoming me to this show. It's an absolute pleasure to be with you this morning. So, of course, it's a complicated question. How does one land on anything at all? And one irony of my being in STS is that STS didn't really exist as a field when I landed in it. So it was, in some sense, trying to make sense of the place that you've arrived in without knowing what that place is. But I think that the preparatory steps were actually far more to do with law than with science and technology, because to some extent, I think the law asks questions about human experience that are quite similar to the questions that STS scholars ask about science and technology. And I think at the core of it is why do we believe the things that we do, and what authorizes us or compels us, as the case may be, to act in particular ways. And I think that those questions can be asked just as much about science and technology as they are continually asked about law. So I fell into this somewhat by accident because I had been practicing environmental law, but for family reasons, we ended up at Cornell University, which is a major university that likes to say that it's centrally isolated. It's in upstate New York, in a very beautiful region. It is part of the Ivy League of American universities, but there's nothing around. Miles of cornfields and to some extent wineries these days. So there was this big university sitting in a place where I couldn't practice the field that I had landed in when I finished law school, namely environmental law. So then the question arose, where in that university could I sit? And people found this program on science, technology, and society. There was nothing there in a sense. That is, it was a program, and so it didn't have a discipline, it didn't have faculty, and to some extent it was groping in the dark to figure out, well, what are the questions to ask here anyway? But because my work was about the environment, I was quickly led into a comparative project. And that was comparing the way in which different countries, 3 European countries and America, regulate substances that are suspected of causing cancer. So, in political science at that time, people thought that this was an uninteresting project because these 4 countries were very similar. They were all democracies, they all had a chemical industry, they all had public health and safety movements, governments were committed to protecting the public welfare. So what could go wrong? Nobody wanted to have cancer-causing chemicals. And the first big insight of my research career was that that was all nonsense. That, in fact, there was a science about different chemicals, but countries nevertheless came to very different positions. And that puzzle is what set me off on my research career. But it's important to recognize that it came out of a project on comparative regulation and not science and technology studies as such.
Yes, that is indeed very interesting. And I think it does make us think about sort of very integral relationship between STS and looking at the law as well. What do you think makes the insights of STS a particular point of relevance to law of legal thinking? I know you kind of alluded to it, but just in particular, as a general conceptual point. Um, yeah.
Yes, well, thanks for that question. I mean, my own answer to that has been evolving with my um, attempts to define and redefine the field of STS in a way that makes sense. So, at the very most abstract level, you can think of legal studies as having to do with, how is there such a thing as law that people believe in? I mean, why does everybody have a mental image of what it means to be lawful or lawless? And, we couldn't live in modern societies without a sense of that. So now, if you just transpose that and say what makes us think that there are such things as scientific truths, and that what is a scientific fact? I mean, it's a commonplace. Everybody kind of understands what a scientific fact is, but people don't stop to think how either thing gets to be what it is. I mean, how does a legal decision become a legal decision? I still remember, the sort of boot camp environment of first year Harvard Law School, when you were told that you more or less had to shed any preconceptions about what the law is and sort of relearn the basics of how one gets to a legal decision. You're not born knowing what a holding is in the law. It's something that's a result of training. But people take scientific facts much more for granted. And I think that the kind of revolutionary move in STS was to say that scientific authority is really not different from other kinds of authority in the sense that we can study how it's made. So I think that the points of contact, the law part I was already used to. Mind you, nobody ever teaches that in a course like jurisprudence. It's much more formal. So I had to reflect on it. I had to reflect on the fact that I was learning how to do law in ways that no classroom course was teaching me. But then the transposition to the fields of science and technology became easier in a sense because I had already experienced something like that process of taking apart authoritative statements, asking how they got to achieve that authority status, and recognizing as well that there's both a kind of technological dimension behind it, that is, rules by which you must operate. After all, lawyers and judges have a deep understanding and a shared understanding of what is not a legal case. You couldn't have a law of standing unless you had some sense who is allowed to come before the court. So similarly, you can ask exactly the same questions about science. How do people know that this is a scientific method or not? So I think that, once you start seeing both science and law as effectively grand machines for producing types of authority, then the intellectual transition between the one field and the other, legal studies and science and technology studies becomes almost natural.
And I think in relation to that, actually, the concept of co-production kind of leads through much of your work, and I think is very relevant to what you've mentioned here. So, talking about this notion of co-production that you also use as a framework throughout your lectures, could you explain to us what the term co-production means and kind of what its significance is in looking at this relationship between science and law?
This question about co-production is really at the center of my academic work, as you point out. But first, I should say that there are two rather different meanings of co-production abroad in the world, and I want to set the one aside as not sufficient, relevant but not sufficient. I call that the Miramax version of co-production. So if you go to see a film and the credits are running, at the end, it'll often say, "This is a co-production of," and then it'll say Dolby sound systems and, whatever other technical production systems were in play. And that co-production simply means that the project needed the input from a number of different fields. So in regular everyday usage, it's often translated to mean that different interest groups came together, sat around a table, and co-produced a common statement or a common position that they all could believe in. I think that the STS version of co-production is stronger than that, because it's not only about coming to a shared conclusion about a set of propositions or statements that you can make about the world, but it's also at the same time, in a sense, bringing that world into existence in a full-blown way. Now, that is a kind of abstract statement, so I prefer, like any good common lawyer, to give an example and say what we mean. So before the late 1980s, people were not talking about climate change. In fact, in American policy, you can almost date it to a particular summer of 1988, when a particular person who worked for our NASA agency on space and the atmosphere broadly, who testified before the US Congress that such a thing as climate change existed. That doesn't mean that there wasn't a climate change before, nor that weather has stopped existing. You couldn't have British everyday converse unless weather continued to be a coagulating word for all kinds of positions. But once you displace weather with its vagaries of changeability and day-to-day prediction with an idea like climate, you've suddenly created a new state of the world, a state of the world that demands, in a sense, that you think differently about it. You produce different facts about it. You ask questions about climate change that you might not ask about any other kind of atmospheric phenomenon, certainly weather. One doesn't talk about climate prediction on one's telephone app. One does look at weather predictions. So this transposition has a temporal dimension, which is profoundly technical, but it also has a political dimension and therefore also a legal dimension. So how is one going to make an accord over the climate now suddenly becomes a normative question in the world if we've learned to recognize that there is this big set of changes to which we've now given a new name, we have new ways of studying it, new facts we're generating about it. What is the simultaneous set of obligations upon us as a human species? And I'll just end with talking about this slew of cases that have arisen recently about the future, the long-term future. Sometimes these are brought by children's groups who are saying that we in the present, the grown-ups of the moment, who Greta Thunberg, the climate activist, loves to excoriate, that we are imposing burdens that take away the people who are as yet unborn and who are children right now to live in a stable world, as stable as their parents may have inherited. So this is moving obligations down the line to a kind of a set of questions and a kind of argumentation that people would have dismissed as speculative only a short time ago. So I think that recognizing that there are these metaphysical changes in our understandings of the world that bring with them, that entail corresponding normative shifts about responsibility, about the locus of responsibility, whose job is it anyway, about the locus of responsibility to whom, who are the harmed parties. These are all profound and fundamental questions for the law. And so I think that the understanding co-production in that sense, that it is a shift of position, a shift of attitude with regard to questions of how should we live together and apart, along with, well, what is the world like that we're choosing to respond to it in this way and not in others?
That is indeed very interesting. And I think it's at the heart, as you said, of STS. Thank you for that clarification. So, in your work, you highlight this broader slippage of power from law to science, where we may have, in ways tacitly granted science and expertise, a higher role as sitting above the normal fray of politics and therefore also law. What causes this sort of inclination? And if we ought to push back against this, how can we effectively do it?
Again, you raise really interesting questions about why it is that we've delegated this decision-making power, this overarching decision-making power, to science, and then what can we do to regain it? I think that my work is more ambivalent about both of these questions. So in a lot of my work on law, I talk about the kinds of games that legal thought plays. On the one hand, according a kind of supremacy to science, but on the other hand, retaining so much discretion to say what counts as science in a given context that actually the law's judgment retains a great deal of decisive power. So let's take again an example that is very current in American policy right now. In 1970, we enacted at the national level the Clean Air Act. That was the first major federal law regulating something in the environment, but 1970 was well before the 1980s when we started recognizing climate change as a phenomenon. So American environmental law has no specific legislation that is geared to dealing with the problem that most people consider the most urgent in environmentalism today, namely climate change. So we don't have a law that addresses that. In between, American politics has become so fractured and polarized that we seem to not be able to muster consensus on anything short of the Epstein files, which, as you may know, yesterday got a ringing endorsement from the US Congress. I think this was the closest to unanimous consensus that we've seen. So on environment, we don't have anything approaching that sort of a consensus. So it's clear that we cannot enact new legislation to confront a very important problem. What does the law do? The law uses this ingenuity to say, well, are there ways that we can stretch the meaning of the old words to cover a new problem? For that, of course, you have to go to the wording of the law. And the Clean Air Act has this word endangerment. So anything that endangers public health and to some degree public welfare and is airborne can be regulated under the Clean Air Act. So in 2009, the Environmental Protection Agency finds that 6 greenhouse gases endanger public health. That sleight of hand, if you will, or bowing to scientific consensus, if you will, brings the problem of climate change within the regulatory ambit of the Clean Air Act. It's no longer ultra vires in any sense. It becomes part of the implementation of the Clean Air Act. So lawyers are intelligent and they recognize that if there's a hook on which you're hanging a set of obligations, if you destroy the hook, the obligation disappears. So in the Trump administration now, there is an effort to get EPA to deny and pull back its endangerment declaration. So it's sobering in a sense that the that the entire regulatory might of the largest economy in the world to deal with a problem that is confronting all of humankind rests on a scientific finding ratified in law. And it's a declaration. I mean, that's even, one could ask, well, what kind of legal beast is this anyway? What is a declaration? But everybody recognizes that if you want to build a lawful world, you really can hack away at that declaration. And if you remove it, it will dismantle the US government's capacity to deal with climate change without new legislation. So that is a big deal, yet hanging on a triviality in a sense. And it's that sort of contradiction that I find truly fascinating in the sort of joint study of STS and legal studies.
Yeah, I guess what I pick up from that is that there's this importance in two things in terms of language and the use of, I guess, word and language to determine something. And then from that, it's kind of categorizing something as being scientific or political, and kind of those being seen as separate aspects. And I guess what you say is that science is seen as something that we can accede to, and then they can kind of allow us to push forth certain regulations. But I would you say then maybe perhaps judges may be inclined to categorize certain things as scientific if they want to see certain results?
I think the judges can both declare something to be scientific and undeclare it as well. So if a judge is persuaded that a certain kind of testimony should not be allowed into court, there's a great deal of discretion to say that the person bearing that expert judgment is not qualified on a number of grounds. That's a very obvious and everyday kind of occurrence. So you're going to let this expert come in. And, it's one of the talents of modernity that we figured out how to generate experts for almost anything. So in the waning days of the COVID pandemic, when we had nothing better to do other than sitting at home and reading newspapers or whatever, I was quite amused at the sheer inventiveness of the category of expert. So I remember one article talking about the effects of the pandemic on ethnically and racially mixed couples. Now, it had not occurred to me that this was a problem to even think about. But what leapt out at me from that fluff piece was that they had consulted experts. So, who would have known before the pandemic that there were experts on how a pandemic affects mixed couples? So it struck me that that was a brilliant example of our inventiveness in saying, give me a problem, any problem, and I'll find you somebody who can speak with authority about it. That is the expert. But equally, the law is extremely good at deconstruction. So the law can take apart the qualifications and say, you're doing nothing more than what a layperson would have done, or you didn't have the qualifications you say you had, or this particular type of problem is not within your domain of expertise. And the law judges continually make those moves. So in a sense, I think that the upper hand very often remains in the court system, in the legal system, to allow in or not allow in people that would be considered experts. And sometimes it's a very good thing, and other times it's problematic. So there are definitely forms of expertise that are not relevant to the normative question that should be asked. And then it becomes dangerous to rely on the separate authority of science and technology to sidestep, in a sense, the normative question and substitute an alleged um, shared respect for science and technology to override what should have been the normative question being asked. So one sees risks in either direction, either setting aside what should be given respect within science or invoking scientific authority to sidestep a question, and one sees both of these kinds of dynamics playing out. So, my message to legal scholars is, become attuned to those particular dances. It'll make you a better advocate for the positions that you want to stand for. it'll also make you a better social critic about when not to over-rely or not to under-rely on the achievements of science and technology.
A lot to think about there. Thank you. Um, I think we should move on to the discussion of issues in the realm of intellectual property and inventions, which you've written much about in the context of STS. And I think the discussion would be illuminating for viewers to appreciate the broader positions you put forth as well. So, looking at, with regard to patents, you pointed out that as a society, we act with the implicit assumption that invention is necessarily aligned with the public good. What is the danger of this, and what role do the courts play?
So I think that the danger of patents as a guardian of the public good goes way back to the theory of patents themselves. So the idea has somehow been that if you give somebody exclusive power to benefit economically from their intellectual property, this will lead to greater inventiveness in society. Plus, there's a kind of Lockean argument that the inventor's labor went into producing the good in question, and therefore they should be allowed to benefit from that. Now, there's very little evidence that inventiveness works for that reason. No, I teach at Harvard, but down the street in Cambridge, Massachusetts, is this other great university, the Massachusetts Institute of Technology, MIT. And MIT's self-image is that it is the school for nerds. And nerds are defined as people who love to tinker with things, not because they necessarily have dollar signs dancing over their heads, but because in today's undergraduate parlance, it makes cool things. So I think that there's a lot of sociological evidence that people do like to tinker, that they do get ideas and they make cool things, as much in legal argument as in technology, by the way. So it's not clear that the economic theory underlying patent law is, in fact, something that stands up to sociological analysis. But setting even that aside, patents can become a safeguard or a safe place for people to retreat to avoid inventiveness. So the phenomenon of evergreening in the pharmaceutical industry has been cited as one of these places that could be seen as a pathology of IP law, that you can take a drug and tinker with things that have very little to do with novelty. So you can, for instance, change the delivery. It used to be an inoculation and now it's a pill. Or the pill itself is configured in a way that alters its uptake into the body. Nothing new has been learned about the biochemistry of the cure itself, but something has been done enough to give people an added length of time to essentially skim the profits from that invention. So this is an entire industry where the argument has been made that from an economic standpoint, the incentive structure just isn't working in a way that would produce public benefit. And then last but not least, you can actually, if you have a powerful entity with intellectual property rights, it can keep other people out of that domain of experimentation. So this was shown legally in connection with the patent on breast cancer genes that a company called Myriad owned for a time. Their argument was that since their scientists had isolated the gene, they were entitled to hold intellectual property rights. But they were very vigorous about enforcing those intellectual property rights, and they didn't want anybody else to do work on breast cancer diagnostics or cure or therapies. I mean, in effect, they were creating a monopoly on how this major prevalent disease, one of the biggest killers, especially of women, could be approached, because their intellectual property rights were setting up a kind of high barrier over which very few people could climb. So that's a fairly recent and rather poignant example of the way in which intellectual property not only prevents inventiveness inside of the allegedly inventive institutions, but actually keeps out people who have a better idea, how to do this quicker, cheaper, differently.
Yeah, that is very interesting. I guess in a sort of way you might consider potentially that the rights of intellectual property is not an outright right, that potentially may need to be balanced against other social interests. And I guess that goes into a lot of underlying political
Yes.
theories then as well. Um, I was considering when looking at your book, The Ethics of Invention, I believe published in 2016, you state that new technologies have, and I quote, muddied the line between persons of property by allowing persons, in effect, to distribute aspects of their selfhood in ways that were once unthinkable. And indeed, questions surrounding the object of property, kind of what we can create as an invention or the sort, or what we can disperse, and ownership are difficult and evolving, especially in light of biotechnological developments. However, there's another aspect that I think has been very recently discussed and debated, which is that since your book, there's arising the question of the subject, other than the human subject, regarding inventions and patents. So there was this case, just to outline for listeners, of Thaler and Comptroller General, which was in the Supreme Court in 2023. And Dr. Stephen Thaler, he put forth many cases internationally in a lot of international courts. And this was that apparently allegedly his AI machine had created an invention. Instead of claiming for a patent for himself, he claimed that the AI should be recognized as the owner of the invention. And this was rejected in the UK Supreme Court. However, this raises a lot of questions potentially in the future of intellectual property and technological developments. So I guess my question for you, in light of that case, is that what challenges, if any, may this debate present to what society thinks about the rights and values attached to being human, potentially even, which is a lot more broad of a question? And could this maybe even challenge our moral basis for recognizing inventions? Quite a heavy question.
I mean, I think that the entire AI area, even more than the biotechnological developments of the past few decades, raises the question of what are the boundaries of the human in a very frontal way. And there's no question that we're delegating to these machines, to some degree, aspects of history and memory that operate differently in the mechanical environment or in the computerized environment from the way they do in human minds. So I, by now, have a repository of, a couple of decades of photographs and calendar entries and so forth. I mean, recently I had to fill out a very complicated set of forms that wanted to know everywhere that I had traveled for the last 10 years. And, it would have been impossible to remember most of these things. But of course, we have these aids that now allow us. Now, I think that one thing that's not often discussed, but should be, is that it actually changes one's understanding of what your responsibility is. I mean, so if you've forgetfulness might have been okay at a certain point, but it's perhaps harder to maintain if there are records and anybody could have access to those records. So I think that in legal cases where, some kinds of falsification or misstatements might have been allowable, um, as long as memory was human, there may be slippages where people are where the standards of responsibility for human beings will change. Now, I realize that you're asking the opposite question. When is it that is it the case that we will be attributing increasing ideas of humanness to technology? So there's a part of, my ironic sensibility that says, well, in medieval times, we used to do this in the sense that creatures like termites were held responsible for the eating away of the foundations of buildings, and people actually had excommunication ceremonies to get rid of pests because they were given, in a sense, responsibility. And the comic poem, The Jackdaw of Reims, has a corresponding sort of thing. And it's also a little bit ironic that right now, one of the big movements in environmental law is rights of nature. And people somehow don't put rights of nature where the left-leaning, progressive, youthful idea is, of course, we should be conferring rights to nature, together on the same page as should we make the AI a human agent. But it's a similar sort of question. To what extent should we take an idea of agency that we have previously located phenotypically inside of human bodies and human minds and say, well, now it's distributed? It could affect our expectations of humans, as I was saying already before, that your obligation to remember and keep track of things may be subtly shifting when you have all these records. I mean, in social media, there's a kind of validation of this because people are often pilloried and lose their positions and their livelihoods because it's found that 10 years ago they may have written something that they today would repudiate. uh, so can you repudiate it if you've put it in a machine? Then is that now with you? I mean, imagine the picture of Dorian Gray if the picture, instead of being up in an attic, is actually side by side with you all the time. If you're joined at the hip and you and your alter image, the digital subject, the digital you, is accompanying you throughout your life. I mean, it's a metaphysically interesting set of propositions, and I think the question of agency goes both ways. I mean, when does it get transferred from the human subject into something that is so humanoid? And of course, we're creating these empathy bots. I mean, we're purposefully blurring the lines. Uh, Now, I think it's an open question what the answer is. And in my future work for the next 4 or 5 years, I actually hope to be exploring this in a multicultural way, because I think that human values are different depending on what legal and philosophical traditions people are coming from. What is the nature of the self? And, the word self, we're used to that. But, when I write two words in prose, our and selves, as separate words, my spell check is always trying to discipline me into writing it as one word because it recognizes ourselves as one word and not ourselves as two words. So, it's a very subtle reminder that we're actually putting questions on the table about which, you know, is my spell check actually entitled to agency? That we haven't asked those questions before. I think that people coming out of, simply even a common law and civil law tradition may have very different ideas about this, because you were talking about property before, and property is understood in a different way in the common law than the civil law. For instance, in the common law, the idea of a bundle of rights, that it's a set of sticks tied together and you can give away a piece of it or a piece of that. Um, that's not quite the same way that civil law traditions think about it. Similarly, I was never taught in my common law property class that the right to destroy the object is actually an inalienable part of your property rights, but in the civil law tradition, that is somehow built in. So I think there are interesting discussions. I mean, you mentioned that you're going to be studying French law, and I think you'll discover that even a question like this, on what basis might you accord rights to a non-human object? But then is it non-human when you've actually built it to track humanness? I mean, to what extent are we already sharing responsibilities that to some degree are precursors of the digital world? So, if you just think of ordinary negligence law, we try to make it natural, but in effect, if you have a car accident and you're choosing whether to blame the manufacturer of the car or the conduct of the driver, you're already doing that kind of bifurcation, because back of the manufacturer of the car are designers. So recently in the US, when Volkswagen Corporation was discovered to have defeated EPA's environmental tests by building in an algorithm into its cars, there was a question, was there liability for this? So just for our listeners, the algorithm faked the performance of the car. The algorithm recognized when the car was in test conditions, and in those test conditions, it behaved better in terms of fuel efficiency. And when it was out on the road, it behaved worse. So you would have more emissions in actual road driving than in test conditions. You could pass the test, and then you would be polluting. Well, an engineer was held responsible for this. But one could have imagined the situation. I mean, in other words, there was a case where do you attribute it to the machine and that road conditions are always different from test conditions anyway, or do you attribute agency to this algorithm, but not to the algorithm, but to its designer? So, in a sense, we've trodden this pathway already, and we have a set of answers, which are, in a sense, precedents. But one has to, where the ingenuity of the legal imagination will come in, is partly in deciding, well, what are the analogies? Which are the things that we will mobilize to address these sets of questions that look all new? But we can always relate them back to some experiential precursor.
Yeah, no, absolutely fascinating. I actually noted that you talked about nature and personhood. And personally, I have actually been looking at these two questions, and I find it very interesting that AI and personhood, that's sort of still currently in discussion. But the idea of nature and attributing personhood to nature, for example, rivers and trees, that was kind of a big thing in 2017 when New Zealand first attributed the Wanganui River to be a legal person. That kind of really quickly died off as like a very feasible idea in environmental law, at least from what I've seen, especially in the culture in English environmental law. But I do find it interesting that I'm not sure, I'm just posing this to you, that potentially our interest in attributing personhood to AI is because it's our creation and kind of we're trying to make it more human and humanoid. Whereas for nature, some may argue that actually personhood for nature may be more important because ultimately humans cannot exist without nature and nature should have standing in our legal system, if anything. But it's the fact that it's not kind of in essence related to us and our creations and what we do that we might be less willing potentially to go down the avenue unless you bring up indigenous rights and different cultures understanding of how nature operates in society. I wonder what you think of that.
Well, I think that I was talking before about comparative law as a way into different sensibilities about the kinds of questions you're raising about where do we feel differently about rights for nature because we're dependent on nature. The category of nature itself, depends on where you're situated. If one were to talk about rights of nature in any historical sense, first of all, in America, there was a very famous law article written in 1972 called Should Trees Have Standing? So this was written by a lawyer. This is way before New Zealand grants rights to a river. And also, if you look at other countries, like the Ecuador Constitution, or for that matter, even the Indian Constitution, you find elements of rights to nature thinking going back already several decades. Since 2000, it's become current and popular in environmental discourse to be talking about the Anthropocene, which is a term that recognizes that humans and nature, or society and nature, are completely linked and interwoven. So that then, from a legal analytic standpoint, what becomes interesting is the separation. So, in a way, we're so driven to new things. Rights of nature is a new phrase, and everybody runs off talking about rights of nature. But supposing we instead talked about the dislocation, when is it, and how is it that we started thinking about this thing called nature as being out there anyway and separate, and people might relate it to the scientific revolution when it became possible for us as human agents to other this thing called nature and treat it as different. So what you could be seeing now is a grand course correction that says what happened at the Enlightenment was a kind of faulty separation, largely in Western and Northern societies that bought into experimental science as a way of knowing the human condition, but that for the vast majority of humanity, this is not a separation that ever took place that completely anyway, that the world is, in a sense, much more hybrid, and that it is therefore a kind of product of a way of thinking that creates these boundaries in the first place.
Thank you so much for that wonderful conversation with us, Professor Jasanoff. As our final question, we'd like to ask, if you could communicate one idea from your lecture series to a public audience, what would that be?
I'm here in Oxford delivering the Clarendon lectures on law. So I think that the first message is about the mystery and power of the law as a creative instrument, as an instrument that is every bit as important to us as science and technology are. I think as a society, or as modern societies, we have tended to get a bit seduced by the power of science and technology. We often talk about law as if it is an also ran entity. One often talks about how the law is lagging behind science and technology. The sense I want to restore to people is that law is more ancient than science and technology. How we live together is ultimately of greater concern to us than facts that we know. And I think I would like people to recover the sense of law, not just as an instrument that makes it easier for people to make money or for people to retain rights to the things that they have invented, but as a vehicle through which people assert their moral agency over the ways in which the world is changing. In short, I would like law to be seen as an inventive, creative, and morally essential space, and not delegate those capacities to science and technology, above all, not to AI.
Thank you so much, Professor Jasanoff. Thank you for listening to our podcast, episode 4 today.